Everyday Samurai, Episode 66. Greetings, friends, and welcome to Everyday Samurai, in service to your liberty and the security of a free state. How do you do? You know, there's a samurai maxim that states, after the victory, tighten your helmet strap. This phrase is attributed to the Sengoku Jidai, or period of warring states, warlord Toyotomi Hideyoshi, who is also known as the taiko, or the big drum. He was one that started out from peasant roots, but rose to become the de facto leader of the military government after his warlord master Oda Nobunaga was assassinated, and prior to the victory of Tokugawa Ieyasu at the 1600 Battle of Sekigahara. The taiko, Toyotomi Hideyoshi, was in fact the shogun in all but name. He was not recognized by the emperor as such, but he did hold absolute power. And he achieved his victory largely through practicing detachment, simply taking situations as they come and finding those breaks and opportunities to achieve success. And he always advised that after a great victory, a warrior must tighten their helmet straps, meaning they should be prepared for the next turn of events that will inevitably unfold, to not be attached to situations or conditions as they are, because the nature of things is change. Change and impermanence is the nature of reality. Right now, as I record this in December of 2024, there appear to be political changes afoot that are in the favor of liberty. Yet at the same time, we have to look at the light and the dark, the yin and the yang, and recognize that it is a confluence of factors. There are indications of a greater good, potentially, yet there are forces working against the idea of liberty. Certainly, private property is under attack domestically, and great conflict around the world continues to rage. This is the nature of life, and we should always be prepared for whatever might unfold and have a vision of where we want to go, but also be prepared for what we might not be aware of. To expect the unexpected is one of those maxims of the skillful warrior. And one of the great tools that every warrior needs is to have the three skills of mindfulness, which is concentration power, sensory clarity, and equanimity, with emphasis on that equanimity as the core skill, to have no aversion or attachment to situations or conditions, to have no push or pull against the inevitability of change. So every victory should be prepared for the counter-reaction. Recognize that there are entrenched bureaucracies, there are those that make their living through taxation, predation, and parasitism that will indeed counter-attack any advancement towards liberty. And while certain personalities might hold office for a short amount of time, the general trend of things is towards technocracy, it is towards control, it is towards tyranny, because that's the nature of politics. So I don't have a lot of time right now, and I want to jump right back into our continued reading of Dr. Edwin Vieira's By Tyranny Out of Necessity, The Bastardy of Martial Law, because it directly addresses these situations and what can be done about it, specifically recognizing that plans and policies and legislative authorities are in place to implement martial law, and that there is also a remedy thereof found in the supreme law of the land, which is, in the United States case, the Constitution. And right now, the United States is the only chartered polity that has a Second Amendment. Yet if you've been listening to the show, recognize that arms are only one component of that necessary condition, which is to have well-regulated militia. What is well-regulated? That's the whole population except for public officials. Exclude those that make their living through taxation, being organized, armed, and disciplined, and actively engaged in executing the law, repelling invasions, and suppressing insurrections. That's what prevents the centralization of martial power, that we the people must be the executors of the law. And that is the only way to prevent tyranny from arising. And it's not about revolution, it's not about revolt, it is in fact a matter of maintaining law and policing the corrupt ambitions of politicians and bureaucrats. So we talk about the tools of liberty, which would be jury nullification, secession, and in the worst case, revolution. But in the case of the United States, no revolution is necessary. The right tools are already in place. It's we the people at the most decentralized and localized level, executing the law, and repelling the insurrections against constitutional order. Remember, we the people are the government, not the politicians and bureaucrats. So keep that in mind as I continue with this reading of By Tyranny Out of Necessity, the Bastardy of Martial Law. The theory of martial governance today is that rogue officials may deploy military and paramilitary forces anywhere within the United States in order to impose law and order. The assumption of the Homeland Security establishment is that sufficient forces are available to set up at any time and to maintain at all times martial governance in any and every state and locality, even in the face of a sizable rebellion or the activity of guerrilla or paramilitary units. Given that theory and that belief, one must wonder whether those officials imagine that they have already occupied this country in principle and are merely awaiting the excuse to occupy it in practice. As noted above, with successful occupation would come military government, simply because the invader has rendered the invaded government incapable of publicly exercising its authority and has successfully substituted its own authority for that of the legitimate government in the territory invaded. And now he is going to quote from a military manual, FM 27, TAC 10. Quote, military government is the form of administration by which an occupying power exercises governmental authority over occupied territory. The necessity for such government arises from the failure or inability of the legitimate government to exercise its functions on account of the military occupation, or the undesirability of allowing it to do so. Paramount authority of occupant, the functions of the hostile government continue only to the extent they are sanctioned by the occupant. Functions of local government, the occupant may, while retaining its paramount authority, permit the government of the country to perform some or all of its normal functions. Such action is consistent with the status of occupation, so long as there exists the firm possession and the purpose to maintain paramount authority. End quote. So, in a war on domestic terrorism today, rogue officials, military or paramilitary forces deployed to occupy some territory could simply assert that the existing legitimate state and local governments were somehow incompetent or otherwise undesirable, and therefore could suppress them straight away, thus bringing about the necessity of military government. Or those forces could prevent such lawful governments from exercising their functions on account of the military occupation itself, with the identical result. Thus, were such a war to extend across this country, as in the event of national economic collapse and concomitant civil unrest on a large scale, the entire federal system could be eliminated and military government substituted for it. No matter how capable the existing state and local governments could continue to function in the absence of interference from the forces of occupation. Moreover, even if the occupant permitted some vestiges of the state and local governments to remain in operation, those governments would nevertheless be wholly subordinate to the occupant, which would retain firm possession of the territory, and the purpose to maintain paramount authority. In the final analysis, then, it is immaterial whether the government over an enemy's territory consists in a military or civil or mixed administration. Its character is the same, and the source of its authority is the same. It is a government imposed by force, and the legality of its acts is determined by the law of war, not by the Declaration of Independence, not by the Constitution and the laws of the United States which shall be made in pursuance thereof, and not by the constitutions and laws of the particular states or localities immediately affected, but instead by naked force under color of the law of war alone. Thus, in the final analysis, the entirety of martial governance reduces to Rule 223 and 308, sometimes styled Rules 5.56 and 7.62. To be sure, the authority of the legitimate power having in fact passed into the hands of the occupant, the latter shall take all the measures in its power to restore and ensure, as far as possible, public order and safety, while respecting, unless absolutely prevented, the laws in force in the country. But in restoring public order and safety, the occupant will continue in force the ordinary civil and penal criminal laws of the occupied territory, except to the extent it may be authorized to alter, suspend, or repeal such laws. These laws will be administered by the local officials as far as practicable. Crimes not of a military nature and not affecting the occupant's security are normally left to the jurisdiction of the local courts. And again, this is Dr. Vieira quoting pieces and parts from the military manual. Thus, in the event that rogue officials in control of the general government launched a nationwide war on domestic terrorism, the laws that existed in various states and localities prior to their occupation, and the force of which would otherwise have continued, could be negated in their every particular, from enactment to interpretation to enforcement at essentially the whim of the occupant. For the law of war empowers the occupant to determine to its own satisfaction whether in any particular instance the qualifications on its authority, expressed in the weasel words as far as practicable, unless absolutely prevented to the extent it may be authorized, and not of a military nature and not affecting the occupant's security, have or have not been satisfied. In particular, the occupant may alter, repeal, or suspend laws of the following types: legislation constituting a threat to its security, such as laws relating to recruitment and the bearing of arms; legislation dealing with political process, such as laws regarding the rights of suffrage and of assembly; legislation the enforcement of which would be inconsistent with the duties of the occupant. On the basis of that purported license during a war on domestic terrorism, which rogue officialdom set out to wage against common Americans, the occupant could be set aside the Second Amendment, the First Amendment, all laws relating to elections, and any other laws it found inconvenient, because the occupant would be the sole judge of what constituted a threat to its security, as well as what were its own duties. The international law of belligerent occupation does provide that the ordinary courts of justice should be suspended only if a. judges and magistrates abstain from fulfilling their functions, or b. the courts are corrupt or unfairly constituted, or c. local judicial administration has collapsed during the hostilities preceding the occupation, and the occupant must set up its own courts to ensure that offenses against the local laws are properly tried. In such cases, the occupant may establish courts of its own and make this measure known to the inhabitants. But if, in the course of a war on domestic terrorism, the judges and magistrates in an occupied territory were patriots, they would surely refuse to serve as puppets for the occupant. So the ordinary courts would be suspended, in fact. Conversely, if the judges and magistrates were compliant quislings, willing to stooge for the military government, then the courts would be corrupt or unfairly constituted, albeit in favor of the occupant, so that although not suspended in fact, they would be perverted in law, and whether the occupant allowed courts of that ilk to continue to function or established entirely new courts of its own would make little practical difference to the inhabitants, because in either case the judges would be doing the occupant's dirty work. Finally, if the local judicial administration had collapsed during the hostilities preceding the occupation, because most of the judges and magistrates had been killed while resisting as belligerents, seized as prisoners of war, or for some other reason driven out of or interned, the fault would lie with the occupant, and that the occupant might then establish courts of its own would be of primary value to the occupant as a means of pacifying the population by providing a simulacrum of legal regularity to a community the original authentic legal order of which the occupant itself had destroyed. Although the occupant's implicit claim to be considered somehow a benefactor in this situation might not be quite as grotesque an affront to common decency as the plea of the child who murders his father and mother and then throws himself upon the mercy of the court as an orphan, the difference in degree should be measured in only a few angstrom units. The ultimate purpose of imposing martial governance, of course, would be actually to govern the residents of the occupied territory for the occupant's benefit. For that reason, subject to the restrictions imposed by international law, the occupant can demand and enforce from the inhabitants of occupied territory such obedience as may be necessary for the security of its forces, for the maintenance of law and order, and for the proper administration of the country. It is the duty of the inhabitants to carry on their ordinary peaceful pursuits, to behave in an absolutely peaceful manner, to take no part in the hostilities carried on, to refrain from all injurious acts towards the troops or in respect to their operation, and to render strict obedience to the orders of the occupant. Once again, the only restrictions that might apply to the occupant administering martial governance would be those imposed by international law, not by the Declaration of Independence, the Constitution, and the laws of the United States, or the constitutions and laws of the states and localities being occupied. First, and of course foremost, the residents of the occupied territory who were not executed out of hand as partisans or confined as prisoners of war or interned as protected persons who had committed acts hostile to the occupying power and who were not participants in any active resistance, would not be permitted to organize and arm themselves. The occupant may alter, repeal, or suspend laws constituting a threat to its security, such as laws relating to recruitment and the bearing of arms. Second, such residents would not be suffered to aid any remaining units of the patriotic militia or any organized resistance movement, because the members of those groups would be considered the enemy. Any person who aids or attempts to aid the enemy with arms, ammunition, supplies, money, or other thing, or without proper authority, knowingly harbors or protects or gives intelligence to, or communicates or corresponds with, or holds any intercourse with the enemy, either directly or indirectly, shall suffer death or such other punishment as a court-martial or military commission may be directed. In the time of war, this rule is general in its application to all persons, whether or not otherwise subject to military law, and without regard to citizenship or military or civil status, who give aid to an enemy government or persons adhering to it. May be that this statute, should it be subjected to judicial interpretation, would be held to authorize the trial of civilians by military tribunals only when the offense had been committed in territory under martial law or military government, or in a place otherwise subject to military jurisdiction. Cases occurring in the United States outside military jurisdiction are triable by the civil courts under the laws relating to treason. The sweep of this asserted authority is breathtakingly broad. In the absence of some contrary judicial interpretation, which as a practical matter might never be had, it supposedly applies to all persons whether or not otherwise subject to military law, and without regard to citizenship or military or civil status, and when the alleged offense has been committed in a territory under martial law or military government, it is not triable by the civil courts under the laws relating to treason, even though it may constitute treason in the full constitutional sense of that noun. So in this regard, martial governance, the contemporary merger of martial law and military government, would simply set aside the basic constitutional protections relating to the charge of treason. Moreover, inasmuch as in the course of a war on domestic terrorism, in which the vast mass of the population disaffected from rogue officials in control of the general government would, to some degree or other, hold some intercourse with the enemy, either directly or indirectly, all of these people would be subject to trial by military tribunals, and would be exposed to the penalty of death or such other punishment as a court-martial or military commission might direct, even though a legitimate Congress had never prescribed any such punishment. Third, the occupant could impose many other controls and restrictions on the freedoms of residents in that territory. The belligerent occupant may establish censorship of the press, radio, theater, motion pictures, and television, of correspondence, and of all other means of communication. It may prohibit entirely the publication of newspapers, or prescribe regulations for their publication and circulation. The occupant is not required to furnish facilities for postal service, but may take charge of them itself, especially if the officials of the occupied district fail to act or to obey its orders. The occupant may withdraw from individuals the right to change their residence, restrict freedom of internal movement, forbid visits to certain districts, prohibit emigration and immigration, and require that all individuals carry identification documents. The belligerent occupant exercises authority over all means of transportation, both public and private, within the occupied district, and may seize them and regulate their operation. The occupant has the right to regulate commercial intercourse in the occupied territory. It may subject such intercourse to such prohibitions and restrictions as are essential to the purposes of the occupation. The commander of the occupying forces will usually find it advisable to forbid intercourse between the occupied territory and the territory still in possession of the enemy. Again, this comes from U.S. Army Field Manual 27-10. Fourth, although private property could not be confiscated outright, it could be seized or requisitioned. Seizure could reach everything susceptible of direct military use, such as cables, telephone and telegraph plant, radio, television, and telecommunications equipment, motor vehicles, railways, railway plants, port facilities, ships in port, barges and other watercraft, airfields, aircraft, depots of arms, whether military or sporting, and in general all kinds of war material. Immovable private property could not be seized but could be requisitioned. In addition, requisitions in kind shall not be demanded from municipalities or inhabitants except for the needs of the army of occupation. Practically everything may be requisitioned that is necessary for the maintenance of the occupying army, such as food, fuel, clothing, building materials, machinery, tools, vehicles, furnishings for quarters, etc. Billeting of troops in occupied areas is also authorized. The prices of articles and services requisitioned will be fixed by agreement if possible, otherwise by military authority. Receipts shall be taken up and compensation paid promptly. Coercive measures will be limited to the amount in kind necessary to secure the articles requisitioned. So again, that means the end of the free market. That means the end of private property. That means the end of being able to communicate, let alone defend yourself, your loved ones, and your personal property. That is, the occupant could take whatever it wanted, could pay whatever compensation it saw fit, and could employ whatever amount and kind of coercion proved sufficient to attain its ends. Presumably, this could result in the imposition of the death penalty or other harsh sanctions against individuals who refuse to acquiesce. For in the final analysis, anyone who would resist expropriation of his property could be charged with aiding or attempting to aid the enemy, to the extent of the supplies, money, or other thing withheld, inasmuch as withholding from the occupant anything requisite for the needs of the army of occupation, or necessary for the maintenance of the occupying army, would surely aid any forces of resistance simply by depriving the occupant of those resources. Fifth, the occupant could impose a wide variety of involuntary servitudes upon the residents of the territory it controlled. Requisitions and services shall not be demanded from municipalities or inhabitants except for the needs of the army of occupation. The services which may be obtained from inhabitants by requisition include those of professional men, such as engineers, physicians, and nurses, and of artisans and laborers, such as clerks, carpenters, butchers, bakers, and truck drivers, the officials and employees of railways, truck lines, airlines, canals, river and coastwise steamship companies, telegraph, telephone, radio, postal, and similar services, gas, electric, and waterworks, and sanitary authorities, whether employed by the state or private companies, may be requisitioned to perform their professional duties only so long as the duties required do not directly concern the operations of war against their own country. The occupant may also requisition labor to restore the general condition of the public works to that of peace, including the repair of roads, bridges, and railways, and to perform services on behalf of the local population, such as the care of the wounded and sick, and the burial of the dead. On the other hand, the international law of belligerent occupation would take special favorable account of the quislings who might be found in the territory. The prohibition against forcing the inhabitants to take part in military operations against their own country precludes requisitioning their services upon works directly promoting the ends of the war. There is no objection in law to their being employed voluntarily and for pay in such work. Sixth and last, the occupant would surely grant itself sweeping legalistic immunities. Military and civilian personnel of the occupying forces and occupation administration and persons accompanying them are not subject to the local law or to the jurisdiction of the local courts of the occupied territory unless expressly made subject thereto by a competent officer of the occupying forces or occupation administration. The occupant should see to it that an appropriate system of substantive law applies to such persons, and that tribunals are in existence to deal with civil litigation to which they are parties and with offenses committed by them. Thus, the occupant would sit as both the legislator and the judge in its own case through its own appropriate system of substantive law, and kangaroo tribunals, the substantive law being appropriate and the tribunals being answerable to it alone. Insulated by such immunities in both law and fact, the military and civilian personnel of the occupying forces and occupying administration and persons accompanying them should be expected very quickly to develop an institutional culture, or perhaps cult is the more descriptive term, even worse than what was already taken hold in police forces throughout this country, which not only tolerate but even encourage and reward open defiance of and contempt for the law, public officials' duties towards society, and the basic humanity of others, individual and collective violence, quite often gratuitously brutal and pitiless, and all too often carried to a homicidal conclusion, routine and systematic falsification of official documents and perjury, as if truth counted for nothing in comparison to a misbegotten loyalty to the force, and a stubborn refusal on the part of the offenders and their superiors to accept responsibility for their actions, to make reparations, or even to show remorse, no matter how much utterly damning evidence may be marshaled against them. In sum, rogue officials would impose martial governance in this country because common Americans had supposedly rebelled against the general government under those rogues' control. In fact, those Americans' actions would not manifest rebellion by any fair definition, but instead would constitute expected and justified self-defense against the devastating economic and social consequences of those officials' adherences to the political racketeering business model, attempts by the good people to resist oppression and then to restore their society to political sanity and economic stability in reliance on and according to the principles of the Declaration of Independence and the Constitution. To the extent that martial governance succeeded, though, the Declaration and the Constitution would be completely overthrown, and the political racketeering business model fastened once again upon the rebellious territories by blatant force of arms. This would confirm the cynical wisdom in the observation attributed to Stalin that the forcible imposition of the political, economic, and social systems an army represents is inevitable in whatever territories it occupies. Thus, martial governance would signal a new regime's being cemented in place as far as rogue officialdom's army could extend its control. In its most repressive aspects, this new regime would be explicitly predicated upon war between rogue officialdom and the good people, a total war, interminable and relentless between the irreconcilable ideologies of power on the one hand and liberty on the other. For on the one hand, once the Declaration of Independence and the Constitution had been rudely set aside in favor of the international law of belligerent occupation, rogue officials, if only for their own protection against the retribution they deserved, could never allow anyone to proselytize, let alone to work for those laws' reinstatement as the supreme laws of this land. And on the other hand, the good people could never allow rogue officials to prevail in such oppression. That, then, is the lugubrious picture of what martial governance would minimally entail in the event rogue officials should decide, as probably they will, to wage a war of domestic terrorism in the guise of a war on domestic terrorism in this country in the foreseeable future. What it could maximally entail, only heaven knows. It also provides an outline of the legalistic rationalizations which those officials would almost surely proffer as their excuse for dealing in that manner with what they would describe as domestic territory recovered from rebels treated as belligerents. Rationalizations would not be justifications, however. Rogue officials might be able to define the rules of martial governance in the same way the author of a children's board game could arbitrarily define its simple-minded rules of play, but they could not defend their rules in the arena in which a defense would be necessary, and then with the requisite arguments. Rogue officials would invoke the unwritten law or customary law of war, arising from the general consent of states and to be found in judicial decisions, the writings of jurists, diplomatic correspondence, and other documentary material concerning the practice of states, that is, every imaginable source except the Declaration of Independence and the Constitution, but they could not explain by what concatenation of legal reasoning they had arrived at the conclusion that the law of war and the international law of belligerent occupation might be imposed upon this country, perforce simply of officialdom's announcement that it was levying a war on domestic terrorism against otherwise innocent Americans who dared to resist its oppressive rule. And rogue officials could not even attempt to explain how the regular armed forces, which are the entirely contingent creatures of Congress, and therefore at best the mere byproducts of the Constitution, and in the final analysis of the Declaration of Independence, could lawfully act outside of, and even contradictory to the Constitution and the Declaration, subordinating both of them to the law of war, which created neither the Declaration, nor the Constitution, nor Congress, nor the armed forces. Rogue officials could provide no such explanations, because no explanations would be possible, then any more than they are now. Anyone conversant with the Declaration of Independence and the Constitution should know that any attempt to discover either a plausible or an arguable, let alone a clear and convincing, basis for martial governance in America's foundational legal documents runs headlong into numerous insuperable difficulties. Nonetheless, in light of the delusions that hold sway among large segments of this country's population today, the subject demands further painstaking analysis, and deservedly so, in light not only of the particular delusions which hold sway today, but also of all of the possibly worse delusions which may take hold in this country in days to come. And remember, he's writing this prior to the COVID lockdown. For although some readers of this book may discount, debate, or even deny that contemporary public officials are actually rogues, bent upon oppressing common Americans in the service of malicious factions and other anti-social special interest groups, no reader can dispute that officialdom is rapidly assembling a national paramilitary police state apparatus and is rationalizing it on the grounds that various emergencies make it necessary and various powers related specifically to war stamp it as legal. Remember, what was the official source of funding for the development of both the antidotes to COVID, and how is the money funneled for the lab that might have developed it? Perhaps some innocent explanation might be posited for this feverish activity, perhaps not. In any event, the fact remains that even if a nationwide crisis which rogue officials could employ to rationalize the imposition of martial law or martial governance did not eventuate in the near future, after all, the police state apparatus now being erected would nonetheless remain in being, complete in its table of organization and equipment, and ready to be set into motion by whatever hands would grasp its levers of control, for whatever purposes the minds which directed those hands might conceive. According to the old adage, time brings all things, bad as well as good, so one must presume that at some time in the future, some cabal of crackpots in public office and their fanatical partisans among the general public will seize upon the opportunity the existence of the police state apparatus will present to them, and will attempt to apply that apparatus to the nefarious ends for which every such establishment throughout modern history has proven itself eminently suitable, namely, in aid first of usurpation and then of tyranny, slavery, and mass murder. That being so, the very first and most important check and balance, which can and should be brought to bear against such an occurrence, is the utter and uncompromising refutation of every legalistic argument in favor of martial law and martial governance, which follows in the remainder of this book. And that is the end of chapter 4. If you like this type of commentary, such as what is being laid out by Dr. Edwin Vieira, you will also enjoy my book, The End of Gun Control, Principles for Securing a Free State, available at shop.everydaysamurai.life, as well as Apple iBooks and Amazon Kindle and print editions. This is where we tie together your individual training in a martial art with the larger contribution to securing a free state. An armed martial art is necessary for your own well-being because people fight with tools. Sport martial arts and empty-handed fighting is great for gratifying the ego, and there might be more money in it, which is why people are attracted to it for its sporting nature. But that is not martial. Martial comes from the god Mars, the god of war. War involves breaking things and killing people, subjecting them to your will through force. And the use of force is governed by the administration of law. Law is the field of politics, setting rules for coercion in society. The Enlightenment theory of politics is that government exists to protect rights, life, liberty, and property. And the United States Constitution makes it clear that no one shall be deprived of life, liberty, or property without a due process of law. Specific to their case, the entire American Revolution was against general writs. But of course, having people being secure in their life, liberty, and property is anathema to those who make their living through taxation, which is parasitism and predation. Yet there is indeed a strong campaign to occupy the cognitive space, which is an influence operation, to convince people that government knows best about what to do with other people's property. This is why the whole people need to be organized, armed, and disciplined in the martial arts to execute the law and maintain constitutional order. But it all starts with the mind. It all starts with you standing guard at the doorway of your mind to know when the use of force is justified, and then having the technical and tactical skills to bring it into execution. So the right to keep and bear arms, the ability to train in a martial art is not just about the individual. It exists within a legal framework. That legal framework is popular constitutionalism, decentralized so that power cannot be held in the hands of the few. And real power, as Mao Zedong so eloquently stated, grows from the barrel of a gun. We train in samurai-related martial arts because the blade is truth. The blade is the science of truth. Science comes from the same root word as scimitar. And discernment is about discriminating between fact and speculation, falsehood and truth. The samurai tradition of Kyojutsu Tenkan Ho, recognizing that there is an alternating appearance of falsehood and reality, and that indeed all war is based on deception. Cutting through deception is part of building that sword of the mind, the sword of the spine, and also having the physical means of rebuking falsehood. This is why the English Enlightenment philosopher Algernon Sidney stated that swords were given to men that none would be slaves. Yes, you need to have the physical means of carrying out your own martial governance, governing your life, and upholding a system of law by contributing to the security of a free state with your martial skills. But you need to have the discernment mechanism within your own mind to cut through delusion, to recognize when you're being gaslighted. This is why books like Dr. Edwin Vieira's is so important, to see how martial governance is being put in place, the apparatus that he was talking about. And this is also why I like to dwell in the solution space, which is securing a free state. Never mind what the tyrants are trying to do. We could see what they're doing. What are we doing? Well, we need to train and we need to organize, arm, and discipline ourselves and connect with our communities so that we can reject their designs and secure our own free state. So that's what his book and my book, again, shop.everydaysamurai.life to pick up a digital copy or go to Amazon for a physical copy of The End of Gun Control. Friends, we hope you've enjoyed this episode of Everyday Samurai and look forward to seeing you next time. Until then, let's connect on Twitter, or X as it's commonly called now. Go to link.everydaysamurai.life to see where you can connect with me, and shop.everydaysamurai.life. Until next time, stay sharp, stay aware, and be well.